Let me now introduce the panel for our first panel discussion on elements of persuasive advocacy and effective cross-examination for international arbitration. The panelists are Mr. Chen Lensang, Senior Counsel, Deputy Chairman of SIAC Board of Directors, Senior Counsel and Arbitrator of the Essex Court of Chambers, Mr. Arthur Dong, Partner of AnJie Law Firm, Ms. Kathryn Sanger, Partner of Herbert Smith Freehills, Hong Kong office, Mr. Tann Chuan Thye, Senior Counsel, Partner of Rajah and Tann, Singapore LLP, and Mr. Thio Shen, Senior Counsel, Joint Managing Partner, TSMP Law Corporation. Moderating this panel is Mr. Cao Lijun, the member of SIAC Court of Arbitration, partner of Zhong Lun Law Firm. A welcome to our moderator and panelists, please.
Good morning, everyone. It's my privilege to be the moderator for this session. As you can see, we have got 5 prominent panelists from Asia. No matter if Asia covers Australia or not, they are prominent. So we are supposed to deal with advocacy through this session. So we will cover from oral advocacy to written advocacy, and also how advocacy should be conducted in virtual hearings. So I think first we will have Mr. Arthur Dong to cover the difference between domestic arbitration and international arbitration. Arthur is currently a partner with AnJie Law Firm. He's one of the leading practitioner and arbitrator from China, having over 25 years of experience in PRC legal industry. His expertise covers international trade, cross-border transaction, corporate shareholder dispute, etc. He's currently a panelist with SIAC, as well as many other institutions such as HKIEC, CTEC, WIPO, etc. He's also serving as a member of the SIAC User Council. So Arthur, the floor is yours, please.
Thank you, Lijun. Good morning, everyone. It's my honor and privilege to share some observations about the difference between the conventional domestic arbitration in China and international arbitration. Since our theme of this conference is on advocacy and cross-examination, so I may share some observations from 3 or 4 points. The first one is on the written advocacy. Second is on the oral advocacy. Third one is on the cross-examination. The final point is about the reform and the change happening in China within 6 or 7 minutes. Yeah. First point about the written advocacy. It's quite different between the Chinese practice and the international arbitration. Actually, in our recent year, in the past 20 years, more than 20 years, when Chinese Arbitration Act was published and got into effective in 1995, Chinese arbitration was to a great extent influenced by the Chinese litigation in the court. So the submission was relatively very short, and the numbers of submission is quite not so many. For example, for a typical arbitration in China, maybe 3 very important submissions. One is a statement of claim. Second one is a statement of defense from the respondent. Third one is a post-hearing brief. In many cases, only these 3 kinds of submissions. So when we talk about written advocacy in China, it's not so complicated, actually. But compared to Chinese practice, when we talk about the international arbitration, we can think about that there's quite a number of submissions. is a challenge to the written advocacy to the advocates, to the lawyers, including from notice application to the reply to notice. When the tribunal was consulted, there will be self-claim, self-defense, and there will be reply and rejoinder, and even rejoinder. And before the hearing will be a pre-hearing submission, and even after the hearing, we'll post the hearing brief. There's quite a number of submissions. So it's we believe there's a higher or requirement for the advocates to show your capability and skill before the tribunal of your written advocacy. Second point is I would like to share the observations about the oral advocacy. Since that in the arbitration in China, there's usually no case manager conference or procedure order, something like that before the hearing. So the hearing goes very likely like a litigation in Chinese court. It goes, the main step is that the statement of claim presented by the claimant, the statement of defense presented by the respondent. Then the most important part of the arbitration in China is the examination of the documentary evidence. It may go quite a long time, for the people to give their opinion, for the parties to give their opinion on the authenticity of the evidence or the relevance of the evidence. And there will be oral argument for 1 round or 2 rounds. Then there will be a closing statement. The closing statement, as by the Chinese practice, maybe only 1 sentence. Do you still stick to your position or not? Do you change your position or not? There's no argument by the closing stage. So but in international arbitration, the most important session is that the cross-examination of the witness, the factual witness, the expert witness. But in China, very rarely there will be witness show up before the tribunal. The most important session is the examination of the documentary evidence. Is true or not, whether you it's admitted or not admitted into the arbitration or not. There will be arguments against targeted on the documentary evidence. So it's a different kind of oral advocacy. Third point about the cross-examination, just like I mentioned in the second point, that since there's very rarely there will be a witness show up in the Chinese arbitration courtroom, hearing room. So when we talk about cross-examination, many people think about that is to cross-examine the documents, not the witness. But gradually in the years, just like I will talk about in the fourth point, that the tribunal, even the court, are encouraging the witness to show up to prove the facts. So it will be also a requirement for the Chinese lawyers to improve their capability to do the cross-examination. And in the international arbitration, on the other side, is very, very important to the lawyers, to the counsel, to prove your case through the process, through your capability of doing a good examination. And the other speakers at a while later will share with us their observations or suggestions how to do a successful examination. The fourth point, the final point I would like to say that is that changes and the reforms are happening in China. 2 points. 1 point is that more through the reforms conducted or sponsored by the Supreme People's Court, witnesses are required to show up before the court the judge. Otherwise, only a witness statement in paper could not be taken, could not be admitted as evidence. This reform began in 2001. when the Supreme People's Court published the first version of the evidence rule of Chinese litigation, and the arbitration communications also take example from that. But the 20 years, almost 20 years later, still very rarely there will be witnesses show up. And just in the end of last year, there will be a second version of the evidence rule of the Supreme People's Court. So again, it emphasizes that if the witness does not show up before the court, that statement of witness could not be admitted as a fact. So we believe it's also the similar situation will happen in the arbitration community. So the cross-examination of the witness will become a must-to-have capability for Chinese lawyers. Second point is that the updated arbitration rules of the leading arbitration institutions in China gradually adopted that the practice to encourage the tribunal to use CMC, procedural order, list of issues before the hearing. So we believe many more written submissions will be required by the tribunal. So written advocacy will be also a new challenge to the Chinese advocates, lawyers. So from the written advocacy to the oral advocacy, there will be a change happening in China to keep pace with the international best practice. Due to the time limitation, I just want to share the observation in respective of the advocacy, comparing the domestic practice and international practice for now. Thank you.
Thank you, Arthur, for highlighting the key differences between the Chinese legal proceedings and the common law proceedings from the advocacy perspective. I think our next speaker will be Mr. Tann Chuan Thye. I hope my pronunciation is correct. Mr. Tann Chuan Thye is a partner with Rajah and Tann in Singapore, which is a leading law firm in Singapore. He's a senior counsel. Senior counsel is equivalent to Queen's Counsel in UK. So it's only awarded to a selected small number of leading practitioners in the legal profession. He covers a broad practice area as lead counsel in various courts and arbitration proceedings. And Mr. Tann has been recognized by leading publications such as Chambers Global in the field of dispute resolution work. Apart from his role as a lead counsel, he also sat on a significant number of arbitration proceedings as arbitrator, and he's on the panel of arbitrators of a few institutions. So Mr. Tann is going to cover written advocacy today. So floor is yours, Mr. Tann.
Thank you, Mr. Cao. I get the easy part. I get the part that has probably changed this, with all of the things that have been happening around the world right now. Written advocacy hasn't changed all that much in this COVID era. It comes down to the same ideas, which I will deal with in general comments at the end. But as you have heard from Mr. Dong, there are different parts or different written parts to an international arbitration. Right at the beginning, you have the notice and the response. The requirements in those documents are specified under the particular rules that would apply to the arbitration. But what I wanted to focus a little bit more in terms of the documents at the beginning would be what are called the statements of case or the statements of defense, or if you're in the ICC proceedings, the memorials. How does one go about this? Remember that this is the first time that you are getting to let the tribunal know what your client's case is. the notice and the response, because of the necessary limitations under the rules, are very brief documents. They are there really to assist the institution understand what the case might be about, and for the institution then to make necessary administrative arrangements. But it is in your statement of case and your statement of defense that you get to tell your client's story. So you need to actually take the time to understand the story. That sounds very basic, but coming from the background that I do, a common law background, it's actually quite a big change, because in the common law practice was really to set out in very brief terms what the essential facts of any case might be. But in an international arbitration, and I suspect also very much in a civil law setting, the expression or the telling of the story needs to be in much fuller terms. So you need to then sit down and understand exactly what the client's story is. And when you are listening to the story, the first question that you have to ask yourself is whether there is a jurisdictional issue. And therefore, because the jurisdictional issue, and you will know this, because the jurisdiction of a tribunal comes from the agreement to arbitrate. Most of the time, you would have addressed your mind to this at the initial stage of the notice or the request. But in the statement of case and defense, you have to spell out why the tribunal has jurisdiction, or conversely, why the tribunal might not have jurisdiction. And when you tell the story, think about it this way, right? You have to write it as though you're telling the story to a young child. I forget where this line comes from, but there's a line that lawyers seem to have echoing in their heads, or should have echoing in their heads, which is to tell it to me as though I'm a 5-year-old child. All right, write it in terms that can be understood that way. And you have to narrate the story or the facts of the story in such a way as it leads to the remedy that you are seeking, or the defense that you are putting up. And as you do the exercise, you are at the same time educating yourself or checking yourself to see whether you can in fact prove the facts that you are seeking to make, whether by documents or by witnesses. And this is a point which I'm sure will come up during the course of the next 2 days, which is that at least in international arbitration setting, be it commercial or investment treaty, documents are best. Witnesses are human beings, their memories fade with time, and memories are inherently unreliable. So check against the documents. When Ms. Zhong talks about how in the civil law jurisdiction, you're looking very much at documents, there's a reason for that. The civil law jurisdictions that evolved from the basis of having recognized that documents are probably the best evidence of what happened in the past. As you are going through the facts, you also have to ask yourself whether there's some form of obstacle to your case. And usually that lies in the realm of illegality, public policy. And then therefore you have to understand what the governing law of the particular dispute might be, and whether there is an issue there. And if you have to do, and if there is that, you have to address your mind to it and deal with it in the statement of case or the statement of defense. And really don't assume, and this goes to timing and planning, don't assume that you are going to get it right in the first 3 drafts. It seldom happens that way. You will write the draft, then you will revise it, then you will strip it apart, and then you put it back together again. And as you do that, bearing this in mind, the more time you spend on a case, the more you will become in a way, blinded to certain parts of it. It's inevitable. So have somebody who is objective and who is not familiar with the case look at the draft to see whether that person can understand what you're saying and whether it's sufficiently clear. There is a difference, of course, if you're under the ICC rules. The ICC rules provide for a memorial system, which is actually different from, I think what I'm familiar with would be the SIAC rules or the HKIAC rules. Memorials are different from statements of case. Memorials require you to attach your proofs of the evidence, as well as any authorities. They're much fuller documents, but in a way, the international arbitration is moving pretty much towards a memorial type style or memorial style way of dealing with the presentation of the written form of the case. Now, assume that you've done that, you've gone through all of the rest of the pre-evidential hearing procedures, and you're now at the evidential hearing itself. Your next document is this thing called an opening submission. Now, although it's called an opening submission, don't fall into the idea that this is where you have to make all of your legal arguments that lead to your result. The tribunal hasn't heard the evidence yet. The tribunal is there to look at the witness statements, hear the witnesses, look at the documents in greater detail. Most of the time, the tribunal will have read the case or read the statements of case, and they know what the case is about. But it would be a stretch to say that the tribunals have dedicated the time to examine all of the facts very closely or taken the time to come to a view. In fact, they would be wrong to do so because you have to approach the hearing with an open mind. Okay, perhaps not a blank mind, but certainly an open. And a tribunal goes into a hearing having a preconception of the merits that it will not move from or needs to be dissuaded from, then I think that there is a problem. So think about the opening submission as a roadmap for the tribunal. You set out for the tribunal in a form, and you will develop your own style on this, that clearly and I hesitate to use the word dramatically, but visually do it in a form that sets out what the issues of fact and what the issues of law are. Tell the tribunal who are the actors, in particular, who are the key witnesses, what are they going to say, what is their role in the dispute. And then what are identified for them, the tribunal, the principal documents. Tell the tribunal what the applicable legal rules or principles are, and put all of this in a way that is easy for the tribunal to pick up. So check your referencing. The referencing needs to be fairly accurate, and make it a point to get these things to the tribunal reasonably early so that they have the time to look at it.
Mr. Tann, we probably would not have that much time to cover all those points. So if you can spend 1 minute to also deal with closing, what are the things to note when doing a closing? All right. Let me. I'm sorry about that. Let me move on then. Okay, so you've done your roadmap, you've done your evidence, you get to closing. The most important thing I want to say about closing is this. You have to start with what the tribunal needs to decide. And so set up, when you start your closing submission, set up really the issues. And this is a practice that's evolving and you need to be aware of it. At the end of the evidential hearing,
Before the tribunal gives directions as to the length and the timing of closing submissions, they will ask counsel to identify or try to agree what the issues for closing submissions are to be. And that goes towards efficiency. And if the chairman would allow me 30 seconds, I will say this. There is one point about closing submissions. It was about 5 years ago that a particular Singapore High Court judge, who shall remain unnamed, actually said when he went on the bench after years of practice as an advocate, he realized that it would help him, and it would help him hold his attention to a set of closing submissions if the submissions set out right at the beginning what the issue that he had like to decide would be and why it was important. And that is after many years of having practiced as an advocate. So the point is this is always evolving. You have to keep learning all the time. And how do you keep learning? And this is why I sound like an old man. One, you continue to have to read outside of your work, no matter how busy you are, and read well. And the other thing is this, in this modern age where we are doing, sending text messages all the time, please take the time to write letters to certain people. And not just confine yourself to social media posts or text messages, because the skill and the practice of actually writing is a necessary one, and you have to keep it up. And the better you write outside of the law, the better you will write during your cases. Mr. Chairman.
Thank you, Mr. Tann, for covering all those important points over this period of time. Our next speaker will be Mr. Thio Shen, also a senior counsel from Singapore. Mr. Thio is a graduate from Cambridge University. He topped English bar examination and was called to the Singapore bar in 1993. And he has been practicing in Singapore since then, primarily as counsel, and occasionally he also sits as arbitrator. He's currently a joint managing partner of TSMP Law Corporation. He has been consistently recognized by leading law journals, including Chambers Global, Legal 500, and other directories. So Mr. Thio is going to deal with cross-examination in 12 minutes. This is a very important part for today because everyone is going to practice how to do a cross-examination. Some will be cross-examined as witnesses. So Mr. Thio, please.
Thank you, Mr. Cao. Cross-examination is a really big topic. We can talk about this for hours, but I have 12 minutes. What I intend to do is talk about 4 things very briefly. 1, what the purpose of cross-examination is. 2, how to prepare cross-examination. 3, how to ask questions. And 4, if I have time to get to it, how to contradict a witness and show that a witness is not telling the truth or being wrong. Now, cross-examination is quite central in the international arbitration process. Even though the international arbitration process is supposed to be a cross between civil law and common law, the truth is the process is much more like common law. There are some compromises, so it's not entirely like a Singapore or an English or an American court, like if you ever watch any of those TV dramas from America. But it is the reason that cross-examination is important is because the common law system comes from an adversarial system. The theory is that if that the truth emerges when 2 sides contest very strongly. That means each side puts on their case or puts at the strongest possible case and argues it. It's met by the other side's very strong argument, and then the judge has to decide by these strong arguments whose argument is better. And of course, in the course of putting across your case, you will say as much as possible in your favor. So cross-examination becomes crucial because cross-examination is there to test the other side's case. So let me start. I mean, there is a fantastic quote which says, which talks about the versatility of cross-examination, and that is, it's this. It says a lawyer can do anything with cross-examination if he's skillful not to impale his own cause against it, which means it's very effective, but you could sabotage yourself if you do it badly. So what is the purpose of cross-examination? I'll start with the simple purposes. The first reason you cross-examine is because you want to basically build up your own case, support your own case theory from the other side's evidence. That means you want to ask questions which get answers from the other side, which support your own case. So this is not about being destructive. This is being constructive. And if you can build 80, 90% of your own case from the other side's evidence, I mean, you're more than, you're on your way to a victory. The second point about cross-examination is this, and this is more common in arbitrations or in adversarial systems. Very often the tribunal might not have read everything. They would have read the witness statements, they would have read the pleadings or memorials, statements of claim, but they might not be so familiar with the documents. So cross-examination is a good time to educate the tribunal, to show the tribunal certain very important documents, ask some questions on them. But the theory is actually to construct the story through using the documents and using the witness to narrate the story. So that's the second point. The third point, the third purpose of cross-examination is the one that we are all more traditionally aware of, and that is essentially to challenge the witness or to test the evidence. So when you do that, you want to test the logic of the case, or their case may be inconsistent with your own documents or your own witnesses. So you challenge them. You say, you said A, but I've got a document that says something else. How can this be true? You might use it to contradict the witness. You might use it to test the witness's credibility. When we talk about credibility, we're not talking about whether the witness is honest or not, but did the witness actually remember things properly? It's about memory. It's about recollection. It's about perspective. Maybe a witness doesn't have all the information. So you say to the witness, well, your evidence is A. But if I told you, but you don't know facts B, C, and D. So if I told you facts B, C, and D, and if these are correct, I mean, do you still take, do you still say A? So you're giving the witness a chance to change their evidence because you're giving them new information, because they may be giving evidence on incomplete information. And then the last thing that you try to do to a witness is you might want, which is part of the challenging of a witness, you challenge their credit. That means you're saying that they're dishonest. You're saying that they're lying. Now, the truth is, some lawyers think every single witness they cross-examination is a liar. That really isn't true. I have cross-examined my fair share of very intelligent and very honest witnesses. But even an honest witness can be attacked on not credit, but credibility, which means they don't remember things properly, they don't have complete information, so their perspective is unique to them, but it may not be unique to the truth. Okay, so that's the first thing. My second point is, how do you prepare cross-examination? Because you have a witness statement, but you're not asking a series of random questions. What you're doing is you're not looking at the paragraphs and just challenging paragraph by paragraph. What you do when you prepare cross-examination is you ask yourself, what are the main points, or I call them themes, and a lot of people call them themes. What are the main themes you want to establish? One, I want to establish that Mr. Tann was at a meeting. Two, I want to establish that Mr. Tann agreed with Mr. Chuan that they would enter into a certain contract, that sort of thing. So you have a series of what I call headlines, broad things that you want to establish, that if you establish every single one of these, you will win your case. Now, a headline is not enough. There will be a whole bunch of sub-points that will establish each headline. So before I can establish that Mr. Tann and Mr. Chuan came to an oral agreement, I must establish that they were both in Singapore at the same time, for example, or in some other country at the same time, that they actually saw each other and had a conversation. So these are the sub points. So you write out, you don't write out your questions first. You write out all your headlines, and you write out the subpoints. And once you have those, then you can decide what sort of questions to write. And it's best to write questions out in a series of statements that you want people to agree to. So statement A, do you agree? Yes. Statement B, do you agree? Yes. Statement C, do you agree? Yes. And when you prepare, you ask yourself, what points can each witness support? Because there's no point asking a witness questions which the witness doesn't know anything about, or that the witness has to speculate on. So you can only ask a witness questions that they know about. You can only ask the witness questions that are relevant to the case. So you can't just say to the witness, oh, what did you have for lunch yesterday? If we're talking about, if it's not relevant, or you know, when did you get married? If it's not relevant. If it's relevant, you can ask it. But relevance is determined by the list of issues or the statement of claim or the case that's being run. So you can't randomly ask questions. One of the things that you also do is you ask yourself, what do I want to prove? And how can the witness escape? How can he find an excuse or wiggle out of the answer? Then you sort of design questions to block off these escape routes. In common law, we call it closing the gates, or bolting the doors. That's what you do. Okay, so third point, how to ask questions. This is important because especially for civil law lawyers, because you don't have that much experience. The basic rule is that you ask leading questions. What is a leading question? A leading question is a question which suggests the answer. So a very simple leading question, leading questions can be questions that are capable of a yes/no answer. Were you at the meeting? Is yes. Were you at the meeting on 10th of June? Yes, no. But you could also ask the question this way. You were at the meeting on 10th of June in Singapore, agree? And the witness will say yes or no. So they're very short questions. Or Mr. Chan, you gave a SIAC panel discussion on the 20th of August. Do you agree? And Mr. Chan will have to say yes, because he's right here on the screen. So those are leading questions, but you want to keep your questions short. So you don't want to ask a question, oh, Mr. Chan, you had a meeting with Mr. Tann on the 20th of August, but you had breakfast, and and in the meeting with Mr. Tann, you also discussed the weather, and you discussed your favorite football club, and you came to a decision that you would enter into a contract because you liked the color of Mr. Tann's shoes. And the witness goes, no. But what is he saying no to? They're like 5 or 6 questions in that question. There are 5 or 6 points in that question. Some may be yes, some may be no, but because you ask it as one lump, one big question, the overall answer must be no, because he doesn't agree, or the witness doesn't agree with everything. So keep your questions short, keep your questions narrow, keep them very specific. So if you're talking about a presentation, you say, you were at the meeting, correct? Yes. At the board meeting. At the board meeting, the CFO gave a presentation, correct? Yes. The presentation was on PowerPoint, correct? Yes. It was also in your board papers, correct? Yes. So you would have read it, correct? Yes. Or you could also ask questions which say, were you at the meeting? Yes. Were you, did the CFO give a presentation? Yes. The reason that you ask a question with a yes or no sometimes is because you want to train the witness to say yes, 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 and hopefully they get used to saying yes to your questions. And the way to do this is to say to a witness, okay, ask a question which is capable of a yes or no answer. Sometimes you follow up with the exact same question, but you show the witness a document. And the document will, of course, confirm that the yes answer is correct. So that witness thinks, well, I better say yes to everything Mr. Thio is asking, because he's got all the documents ready to contradict me if I'm wrong. Okay, so what you need to avoid is you need to avoid open questions. So this is how not to ask a question. Avoid open questions. So why did you do something? How did you do something? Because you want to control the witness. You really just want the witness to say yes, no, agree, disagree, or what. And I tell people there are only 4 answers to any cross-examination question. There are only 4. Yes, no, I don't know, and I can't remember. There are only 4 possible answers. You can say yes and explain, no and explain, or I don't know, or I can't remember, but there are only 4 possible answers. And agree and disagree is essentially yes or no. So you want to keep the witness in that box. But very often, of course, a witness will be allowed to explain the yes or no question. But you always must get a yes or no, I don't know, I can't remember answer from the witness first. Try to get that first. If the witness wants to explain after that, then you let the witness explain. Don't let them explain something that they haven't even answered. But avoid open questions, because that gives the witness a chance to tell their story again. I mean, that's the general default rule. Of course, rules are meant to be broken, and there are times that you ask open questions because, for example, the logic of the witness's case is so ridiculous. So it's so bad that you say, look, given all these facts, can you just explain to me or why you did this? I mean, so and they won't have a good explanation, and you want to see the witness struggle, but you better be very sure that the witness is going to struggle, and that you yourself can't think of a good escape route. So that's when to break the rules. But otherwise, an open question is why, how, what. Those are all open questions. I think I mentioned the multiple question. That's called a compound question. We say don't ask compound questions because the yes or no answer might be meaningless, because the question, the other lawyer say, what did he say yes to? What did he say no to? Now, maybe I'll just move on to a quick last point. Although there are many points that can be discussed. How do you contradict the witness? So, for example, you think the witness is lying. They've said something in their witness statement or on the stand that is just untrue. What you do is this: if they said something untrue, you get them to confirm it in as many ways, so that there's no escape route. They have done a Donald Trump sort of thing. They have doubled down, right? He says, he says that bad people are coming over the border. Then you say, and you get him to confirm. So bad people. Who do you mean by bad people? You mean people who are not Americans are coming over the border, and they're what do you mean by bad people? They're criminals and all that. So you get them to expand on their story, and then you hit them. Usually you will have a document to contradict them. And you show, well, take a look at this document. Is this a document that is important? Is this a document that is likely to be truthful? Then you show them the statement, and you say, well, this contradicts. Do you agree that this contradicts your case? And if it contradicts your case, then are you saying you're saying that therefore your position can't be correct, because many people whom you say are truthful people have said this. Sometimes they have a document that contradicts themselves. They have said something in the past that might contradict what they said today. So once you get them to double down, you ask them, you made a statement 2 years ago in a sworn statement. Do you agree that when you swear a statement, you must tell the truth? Yes. And do you agree that every time you swear a statement, you tell the truth? They'll probably say yes. So you ask them to read out that statement that they made, which contradicts what they just said. And you say, do you agree that these are contradictory? So tell me, were you lying to the tribunal 2 minutes ago, or did you lie to in this witness statement 2 years ago? And then you contradicted them. Now, there are many different ways of contradicting a witness. I've just given you a flavor. But what happens is that not all witnesses, it's not so dramatic as that. Not all witnesses are going to say, yes, I lied, I'm a terrible person, shoot me now and send me to jail. They're not going to say that. They're going to stick to a ridiculous story. Even though in the face of contradictory evidence, they will say, no, I stick to my story. I didn't lie. This is the truth. And you will, and if it's ridiculous, you just have to move on. But what you say is, okay, I will suggest to you, or that what you just said is not true. Do you agree or disagree? They will disagree, and you will say, I'll move on, I'll leave it to submission. Sometimes I say things like, is this the evidence that you want on record before the tribunal? Let me confirm it. Thank you very much. I will make my submissions and move on. We find this evidence ridiculous. Is this what you want on record? I will give you a chance to change your answer. And they double down again. But if they've doubled down on something ridiculous, there's no point arguing or quarreling the witness, because cross-examination, and they say you cross-examine, but you don't ask questions crossly. You ask questions politely. You then say, I will move on. I'll go on to something else. So I will leave you. Now, there's a lot more to say on cross-examination, but I will just leave you with this one thought. Cross-examination is a fantastic tool for exposing lies, for exposing falsity. In the hands of a good lawyer, you can expose falsity. But I will say something that's a little bit more controversial. Cross-examination is okay for getting to the truth of things. It's not the best technique of getting to the truth of things, because very often a good lawyer can sometimes turn a witness inside out in cross-examination and can make a truthful witness come across as untruthful or evasive. So it's great for exposing a lie. It's only okay for getting to the truth, but I think it's probably the least bad way of getting to the truth. So that's, so unless you're omniscient and can read people's minds, we human beings are only left with documents and the ability of the human mind to remember things. So Mr. Cao, I think I don't want to overstep my time. That's all I have for now, but happy to answer questions.
Thank you, Mr. Thio, for covering all those points in a short period of time. I think for those fellow civil lawyers, the number one point to take away from Mr. Thio's presentation is that how to ask questions. During cross-examination, the cross-examiner is supposed to ask leading questions, which are closed questions, not open questions. The number 2 point is that don't make your question compound ones. Just ask simple, short questions. I'm sure everyone will get a practice during today. So please bear those points in mind. Okay, I think Mr. Thio covers cross-examination. We need someone to cover redirect, and that someone is Mr. Chen. Please, Mr. Chen.
Sure, thank you. That was such a very good, fast speed tour of cross-examination. Very interesting, and I'm sure we can listen to Shen for another 2 hours. As he says, it's a very big topic. You can't learn it within 10 minutes or even in 1 day. But he's given you a very good flavor. What happens in a typical setting is that after the cross-examination, then the counsel who represents the parties, who is giving evidence through the witness, will have a chance to re-examine the witness. That's called re-examination. And I'll just say 4 things about re-examination in 1 minute. First of all, you have heard Shen say that the way you ask questions in cross-examination is to ask questions which are more like statements. And these are what we call leading questions. You suggest the answer to the witness in cross-examination, so the witness can only answer in a certain way. And but in re-examination, there's a rule that you cannot ask leading questions. Basically, whether it's examination in chief when you introduce the witness, or when you are doing re-examination, you cannot ask your own witness leading questions which suggest the answer to them, unless it's not a contested one, like what's your name. So what are leading questions? One example is, did you see X when you went to the apartment? That would be considered a leading question because it's suggesting to the witness how to answer the question. And the way that you normally ask questions which are not leading would be like if your questions are who, when, what, and how. So instead of asking the question, did you see X when you went to the apartment? You will ask it, who did you see when you went to the apartment? Another leading question would be, was the road wet when you were driving? That's a leading question. A way to ask it that's not leading is, what was the condition of the road when you were driving? The next point is that you cannot raise any new point that has not been put to the witness in cross-examination. You can only ask the witness something that the witness has been asked by the cross-examining counsel. The third point is you have to be very selective in re-examination. If your witness has said something very damaging, considered something very damaging in very clear question and answer session, sometimes it's best to just leave that alone because you cannot undo the damage. And it will be obvious if you're trying to get the witness to change his or her testimony. And the final point really is that if you don't really have to ask very long a re-examination, okay? Think whether you really need to ask. For example, if the cross-examining counsel has been unfair in requiring the witness to answer just yes or no, and not allowing the witness to explain the context of the answer, you can go to that question and give your witness a chance to elaborate on the answer. But other than that, you normally don't have a long re-examination. And sometimes, if you don't think that there's any damage done to your witness, or that's any damage that you can undo, you can even say no re-examination. And that's my comment, Mr. Chairman.
Thank you, Leng, for the valuable points on re-examination. Our next speaker will be Ms. Kathryn Sanger. Kathryn has over 15 years of experience of advising clients in international arbitration and litigation. She is currently based in Hong Kong. She was the council member of HKIAC for many, many years before 2019. And she also sat on various committees of the HKIAC. Kathryn also speaks Mandarin Chinese. So she has also been recognized by various leading legal directorates. So Kathryn today will cover special features of a virtual hearing, which are truly important this year. So Kathryn, you will have 8 minutes. Thank you.
Thanks, Lijun. So as you said, I'm going to look at advocacy from a virtual hearing perspective, which obviously is very topical at the moment. And I think it's fair to say that the majority of hearings that are going on around the world have some form of virtual aspect. Often witnesses are giving evidence virtually, so cross-examination is taking place virtually. And in some cases, tribunal members are sitting apart from counsel or in mixed bunches around the world. So it is a really hot topic, and you will see that there's a lot being said about it at the moment. I'm going to break with tradition. I have 5 points to cover. I'll try and cover them very quickly. I'll look at the differences in advocacy style when you're dealing with a virtual hearing. I'll look at how to be an effective advocate when you're speaking virtually or dealing with a witness virtually. I'll look at effective witness control, following on some of the points that have been made by Shen and Leng, but in a virtual context. And the differences is the 4th point between a virtual and an in-person hearing. And finally, really some of the common concerns that have been raised in the context in particular of witnesses who are giving evidence, not only often in a virtual setting, but in an isolated setting. Because of COVID, it's very difficult often even to have a neutral observer sitting with a witness, which is one of the things that has been suggested as a way of controlling the way a witness gives evidence, and making sure that that witness, for example, is not talking to somebody off screen that can't be seen by the tribunal. But given the restrictions around the world, it's more common than not, I think, for witnesses to be giving evidence sitting by themselves without a neutral observer being present. So we can talk about that in a little bit of detail. I think the key point to start with, the first point, is the differences in advocacy style. I think it's just that the normal rules for effective advocacy that we've talked about this morning really apply with greater force. There's much less flexibility, particularly as we've seen on timing when you're speaking virtually. So you have to really take steps to be effective, to speak slowly, and that's something that I find difficult in particular. And really less is more. Don't overspeak. Use a much slower style, particularly where you're dealing with internet connections and time lags in technology. It can be more effective to really just deal with the most essential things. Take your witness, take the tribunal only to the most essential documents and the essential points. Don't overspeak. And that, of course, applies to any hearing, but I think it's particularly important in a virtual context. How to be effective, the second point. If there's one thing to take away, it's that testing is critical. Test, test, test. Always try to have a test run. If you're giving evidence before a tribunal virtually, then test that in advance. The institutions are very good at helping you do that. And the transcribers are all offering platforms that help that are very, very effective, but also allow you to test in some form in advance of the hearing. And that, of course, applies to your witness. Make sure where a witness is giving evidence remotely, that's being tested in advance, either before the hearing, or ask the witness to arrive at the venue or to be available to give evidence before the testimony starts, just as we were asked to meet 15 minutes earlier to test before this panel hearing. It's very important to make sure that things run smoothly. Look at the camera, not at the screen when you're speaking. I find that sometimes difficult to do. It can be difficult when you're using notes, but obviously the camera is your eye contact with the tribunal and with the witness. Think about lighting. Think about distracting noises. If you're doing the hearing from home and you know there's going to be drilling, in Hong Kong there's a lot of drilling at the moment, maybe try to ask management to not have the drilling on that particular day, because it can be very off-putting, to say the least. I've come into the office, we're working from home, my younger son started homeschooling today. I knew that that was going to be very distracting in my house, so I came into the office because it's nice and quiet. If you're not speaking, then put your microphone on mute. You obviously need to keep your video on, but be muted so that you're not creating noises when other people are speaking before the tribunal. And think about a practical tip we've been told is don't have your volume to the highest setting, because that can often create feedback when you're speaking. So think about that when you're looking at the volumes on your computer, particularly in the context of testing. And obviously check that what you're reading, your notes, I have notes here, are not viewable by the tribunal on screen, because in the same way as you're in a hearing, think about what is visible when you're giving your advocacy. The third point, effective control. I'm conscious of time, so I'll just make a couple of points. Think about how you're going to take the witness to documents in advance. Think about, are they going to have access to a soft copy of the hearing bundle? Do you want them to have a core bundle that's made available to them? So you really have to be prepared even more than in a normal setting, because the witness may well be sitting by themselves, will have to find the document that you're talking about, and you have to make sure that they've got it and that it's effective. So think about sharing screens, make sure you've mastered the function in advance, or at the very least ensure that the witness has access to the documents that you want to take them to. Sometimes it can be effective to prepare a core bundle, but that can also be a signpost to the witness the documents you're going to ask them about. So think about, at least think about it strategically to make sure that the cross-examination is effective. It's really important in a virtual setting to keep your questions short. Never use compound questions, as Shen has said, but particularly in a virtual setting. And don't rely on cross-examination that needs high pace or pressure, because it's much more difficult to establish that in a virtual context. And that really leads into the differences between in-person and virtual. Getting that rhythm in cross can be harder, particularly where a witness has technical issues. If a witness keeps dropping in and out of connection, then obviously it's very difficult to create a rhythm. So think about that when you're preparing the points you want to make. You may have to be effective in other ways. Ensure that witnesses have access to documents, as we've talked about, and find a way of doing that effectively. And in that context, some of the concerns that have been raised is, how do you know that a witness is not speaking to someone offline? How do you know that they're going to, how do you think about whether, are they more likely to tell the truth in an informal setting than a formal setting? And a lot's been said about that, but some practitioners think that a witness sitting at home or sitting in an informal setting may feel more comfortable and may be more likely to tell the truth than if they were sitting in front of the tribunal. But just think about who you're going to be speaking to and how that might be effective. In terms of checking, some tribunals ask the witness to use a camera to take their video and pan it around the room to make sure you can see outside the camera lens and make sure that no one else is in the room. Ask the witness to show their notes and what they're looking at on the screen to ensure that they're not really in some way cheating when they're giving evidence or speaking to someone offline. I've seen tribunal members use undertakings in terms of undertaking that they will be giving evidence without assistance. If they need someone to give technical assistance, then know who that person is and ask them to identify themselves in advance so that you're not taken by surprise. So I think the point to close is that it can be more challenging, but still cross-examination, as we've heard, is a very effective tool. It can still be effective virtually. You can't see the whole of the witness, and some people say that if you can't see their feet, you don't know if they're telling the truth. But what you can see, and you can see it today, you can see the close-up of the witness's face. You can see the witness reaction. Sometimes it can be more effective focusing on the face. If the witness is sweating, then that may show that the witness is nervous. So that actually it can be, I think, just as effective sometimes as giving evidence in person. But just to conclude, I'd say preparation is even more important in a virtual context, and testing is key. Thank you.
Thank you, Kathryn. Do you think it's necessary for the tribunal to draw the parties to agree on certain protocol, like the sole protocol for the virtual hearing?
I've seen both, Lijun. I've seen where tribunals have quite extensive protocols, and obviously there's a lot that's available online. In a recent case I did, we had 4 witnesses giving evidence virtually, 3 in Beijing and 1 in New York. We had each witness gave an undertaking and that they would, how they were giving evidence, in what context, and who would be with them. And we asked them to pan around the room with the video so that we could see, to check that there was no one else in the room. One of the witnesses' younger sons kept running in, but we made an exception for the 5-year-old that was sitting under the desk. But other than that,
that's very interesting. Thank you, Kathryn. So our last speaker is Mr. Chen Leng. Leng just talk about the tips for redirect, but now he's going to give a talk on the tribunal's perspective about how to do oral and maybe also written advocacy. As we all know, Leng, he is the deputy chairman of SIAC's board of directors. He's appointed senior counsel many years ago in Singapore. He's currently a member of Essex Court Chamber Duxton, which is the Singapore group practice of Essex Court Chambers. The time I first met him, he was the president of Singapore Institute of Arbitrators. I thought that's probably 2013 or 14. Leng has been recognized as one of the top arbitrator in the region by various legal media directorates. Leng, please.
Thank you very much, Lijun. I will jump straight into it and not take too many minutes. Basically, what I like to do is just to look at advocacy from the other perspective, and that's the most important perspective, from the tribunal's perspective. There are many interesting points and very important points that have been made by the other panelists. Due to shortage of time, I will not go through them, but I'll take you through another perspective. And I will start with a song by Meghan Trainor. For those of you who know Meghan Trainor, it's all about the bass. In our case, it's all about the case. And case, as you know, is spelled C-A-S-E. I'm going to make 4 points on the case, and that is C stands for chronology, A stands for authorities, S stands for so what, and Y stands for access. So starting with chronology, C, bear in mind that at the end of the day, the tribunal is interested in the truth about the facts. Many arbitrations involve an attempt at reconstructing events. So it's important to furnish a clear chronology of material facts. Arbitration exists outside of Einstein's space-time complexity, where you talk about time travel. In the search for truth in arbitration, time flows in only one direction. And therefore, when you have chronology, it's easier for the tribunal to understand the story. That's one. Secondly, it puts the factual disputes into context. And thirdly, you can use it to test allegations of one party against another. For example, if A says that he did not know of B's existence until a certain date, the correspondence between them must naturally post-date after that date, happens after that date. So if you find something between them before that date, then something is wrong with A's story. If you put documents, correspondence, meetings, and conversations in the correct order, the true picture emerges. A well-prepared counsel with a complete grasp of the chronology and the facts, will also be able to control and put right a witness who is jumping all over the place with his or her account of events. The second point is authorities, and that's the A in case. These are your sources of the law and legal arguments. Do not push back points of law or try to mislead the tribunal. A counsel once made an argument of law before me and produced an incomplete extract from a textbook. Instinctively, I felt that her argument was wrong. I said her, okay. I looked for the missing page in the textbook myself and confirmed that her argument was in fact incorrect. And I thought that was a bit mischievous. A misrepresentation of the law undermines the counsel's credibility. If adopted by the tribunal, it may well receive the full glare of publicity if the award is tested before a court. And the tribunal who has been embarrassed by the adoption of a mischievous counsel's misleading submission will remember that embarrassment and the counsel for life. Right. The third letter in case is S. And here this is my own acid test. So what? Test every assertion you make with the question, so what? By this I mean, explain the relevance of every point that you make. The tribunal wants to know why parties are fighting over an allegation. Where does this lead to? If the claimant is right, how does that affect its case? And vice versa. Do not leave an assertion dangling, whether it's in pleadings, witness testimony, issues, or submissions. By dangling, I mean, don't just argue and fight over a fact. But where does it lead? So what? Why does it matter to the case? For example, in a sale and purchase dispute, if the buyer complains that the goods were received wet, and they start fighting whether it was wet or dry, the tribunal wants to know, what's the point of this? So is that the seller's fault? Does it lead to rejection of the goods or acceptance with a lower value? Every allegation that you make must have a destination. And the final letter in case is access. I think you have heard about this from other panelists, for example, Chuan Thye, when he's talking about written advocacy. Trim the access, focus on the big points, and Kathryn made that point as well. It's especially important in a virtual hearing. This is what lawyers are for. Clients might feel emotional over insults and injury, but you as the professional must focus on the main issues that can turn the case that will be decisive. If a case is cluttered with 20 issues all demanding the attention of the tribunal, you are not helping the tribunal to spot your strongest ones. Remember that in arbitration, a tribunal can be criticized if it does not decide all the issues put to it. If you do not want to inflate time and cost, or have your killer points buried under a bunch of trivia, do not put unnecessary issues to the tribunal to decide. And remember, for every issue that has been put to the tribunal, please provide complete submissions so that the tribunal is able to write a properly reasoned decision in your client's favor, of course. Thank you, Mr. Chairman. Those are my points.
Thanks, Leng. Time is up. We do not have a sufficient time to cover all. I think within the 1 hour time, we cover most of the issues for advocacy. Either it's oral and or it's written advocacy. But during this 1 hour time, it's apparently not sufficient to cover every point in details. I'm sure my panelists have a lot to say if they have more time. So, and we don't have time to have interaction among us and with the audience. But I think we have laid down the groundwork, particularly for those who are not familiar with how international arbitration are conducted and how in a common law proceeding, legal proceeding is conducted. You can get some basic points and you can keep practice and during the 2 days time. I'm sure you can meet the panelists in different setup over the 2 days, and you will continue to have the opportunity to have a dialogue with the speakers, my panelists, and the other audience. But thank you for your attention. Thank you.
Thank you.
Thank you.